Streaming today, so to those who are watching from afar, welcome to our meeting this morning. Now, please, if you could just turn off your mobile phones, and we will take a break to allow members to clear their phone messages. So the opening karakia this morning is by Councillor Wang. Morena, Councillor Wang, thank you.
Morena. He karakia mō te kaunihera o ngā roto o Rotorua. E te atua ka harawa, ko koe te tohu rangatira, te tohu mātauranga. Manaaki tia mai mātou, wauponanga I tēnei wā. E mahi nei I a mātou mahi, mo te painga o ngā tangata o te kaunihera o ngā roto o Rotorua. Takoa mai ki atu te rangi Mārie ki runga I a mātou I ngā wā katoa. Ko ihu karaiti, hoki tō mātou ariki. Amine. Almighty God, who alone is the leader of all mankind and the fountain of all knowledge, send thy blessing upon us, your servants, this day as we strive to do all things good for the betterment of the people of the Rotorua district. May we be tolerant in ourselves at all times. Through Jesus Christ our Lord. Amen.
Thank you, Councillor Wang. I did omit to welcome members of the staff, Morena Felix, and of course Jeff to you and our staff as well. Any apologies, please? I do have an apology from Councillor Kumar for lateness. That's all I have. Oh, no, here we go. He's here. So, thank you. Oh, yes, Councillor Bentley.
Early departure, Madam.
Early departure, thank you. Do you have an approximate time for that?
Yeah, 11:30.
11:30. Thank you. Thank you very much. So we can move on. Any declarations of interest, please?
Yes, Madam Chair.
Oh, hello. Yes, thank you, Te Kepa.
Ai, tēnā koutou.
Oh, Morena Te Kepa, yes.
To disclose a potential perceived conflict of interest in accordance with clause 20.8 of He Koanga Tohu, Rotorua Lakes Council standing orders. This committee are considering the submissions received for the 2022 representation review and the report prepared by council staff on this. I wish to withdraw from these discussions because my first consideration is to the guiding principle Te Arawa, Mana Whenua and community pride. I believe that to even consider this report places me in direct conflict with this principle because the report does not accurately represent the submissions and ignores the majority that clearly supports 3 Maori seats. The submissions include a submission made by me before being appointed in this role. Therefore, I wish to withdraw from these discussions immediately. Tēnā koutou.
Thank you, Dr. Morgan. Thank you, and you've stated your reasons clearly, so I'm going to accept that you won't be taking part today. Thank you for that. Any further declarations? I am going to, yes, Your Worship, sorry.
Is that, just hearing Dr. Morgan, does the same apply for other submitters? That's just a clarification that we require, because there are other submitters sitting around the table.
No one else has indicated a declaration of interest. What I will be doing is and I ask that the record note that Te Tātou o Te Arawa made a submission on the model that went out for consultation with the community. Also, the Rotorua or RDRR also made a submission on the model that went out, and we have members of that organisation sitting at the table. So I'd like the record note that, please. Yes, thank you. Mr. Rotorua.
Kia ora koutou. Just wanted to clarify also that I played no part in the deliberations for Te Tātou o Te Arawa. I stayed neutral the whole time.
That's correct. That's correct.
Point of order, Madam Chair.
Thank you. Yes, Councillor Donaldson.
Thank you, Madam Chair. In the absence, I acknowledge the declaration by Dr. Morgan. In the absence of any other declarations of perceived predetermination or bias, I'd like the record to note that there was a submission from the Committee of Grey Power, and one of our councillors is a committee member of Grey Power, which made that submission. The instructions or the advice of the Auditor General is quite clear on public statements made regarding the matter before the committee that might give a perception of predetermined or bias. And Councillor McPherson has made public statements on Facebook regarding the issue before Council today. So I just want that on the record. Thank you, Madam Chair.
Thank you. Thank you. We don't declare an interest on behalf of other councillors, but I can note your comments. Thank you. Thank you. And also, I'm sorry, I didn't mean a welcome this morning, Lachlan. Good morning, Lachlan Maldoni. Lachlan is our legal advisor. Morena, sorry that I didn't welcome you. And Dr. Morgan, you're taking part, Kepa, you're taking part by video as well. So any urgent items not on the agenda this morning? No, thank you. Now, I am going to, do I need to move in a seconder? Yes, I do need to move in a seconder for this motion because I am going to seek to have a temporary suspension of standing order number 21.5 that members may speak only once. I think this is a significant issue that we're talking about, the item rather, that we're going to be discussing this morning. So I would like everyone to have the opportunity, if they so wish, to speak more than once. So I'm going to ask for a mover and a seconder, please, to the motion that the committee temporarily suspend standing order 21.5. Members may speak only once to a motion at a meeting for the Strategy, Policy and Finance Committee meeting on the 16th of November 2021. And the second part to that is the reason is to allow members sufficient opportunity to undertake representation review deliberations. Thank you, Councillor Kai Fong. Thank you, Mr. Trumper. It has been moved and seconded. All those in favour, please say aye. Carried. Thank you very much. Thank you. The recommendation on page 7, thank you. Your choice, 2022 representation review, decision making following consultation. Could I please have a mover and a second to receive the report, Your Choice 2022 representation review, decision making following consultation be received? Thank you, Your Worship. Thank you, Councillor McPherson. It has been moved and seconded. I'll put that motion. All those in favour, please say aye. Contrary, thank you, carried. Good morning, Una. You're presenting an overview this morning. Thank you.
I am. Kia ora tātou. Good morning, everybody. So I'd just like to do a few introductions first, just to set the scene for our presentation today. So I just want to thank Lachlan Maldoni, who has been providing us with some advice and navigation through this process following the close of consultation and then your initial thoughts and direction posed to us in a forum back in October. So welcome, Lachlan. Good to have you there. And then on my right, I've got Kihi Tawhai, who is in our governance team and has been part of the wider project team. And also I have Rick Dunn, our governance manager. So the three of us today are going to just give a really high-level overview of, I guess, the process from when the consultation closed, and then setting the scene in terms of the detailed report that was in your agenda paper. When we get into the questions time, if there are any questions around sort of the legal process, Lachlan will be our person and first point of contact there. So thank you. So just to go over the purpose of today's presentation and the paper in your packs, it is an opportunity today to consider the submissions that have been received and to make a recommendation to Council on a final representation model for the 2022 and 2025 local elections. And with the timeline set by the Local Electoral Act, this notification of a final model must be publicly made by the 19th of November. So that's the end of this week. So, councillors, you will recall that when you started the journey in terms of the representation review, you set a number of guiding principles, and we're just going to go through those now. The first one was around keeping the model simple. This council encourages all eligible persons to have their say on the best people, the best makeup and structure to represent the Rotorua district. So therefore, a model needs to avoid a level of complexity and confusion that may create barriers to understanding the way voters can vote, and if it is too complex and confusing, could lead to a poor voter turnout. There was also a guiding principle around the total number of councillors, and there was very little debate that a move away or a shift from the existing 10 councillors should be considered. Council agrees that the total number of councillors should reflect our district's diversity and ensure voters can easily engage with councillors, that there is a balance of the workload between all councillors, and that councillors and people who are representing this district can bring a range of skills and knowledge to the table. And ultimately, the people sitting at the table and making decisions are making decisions that represent the community's needs and interests across the district.
Thank you, and Morena. To meet the requirements of the Local Government Act, there are a number of guiding principles, and some of them are around fair and effective representation. So we must provide for effective representation of communities of interest and fair representation of electors. Therefore, there are three factors for local authorities to carefully consider, and they are communities of interest, effective representation of communities of interest, and fair representation of electors. And so part of that is identifying communities of interest within the district. Also, whether these communities of interest are located in identifiable geographical areas, and justifying the establishment of wards. There's also the basis of elections that needs to be considered, and this is whether the elections or it's at large, the proposal is at large, whether it's a ward system based on wards, or in fact a mixed representation model.
And also there was recognition for acknowledgement of tangata whenua and maunga whenua, in particular the Treaty of Waitangi and the Rotorua Township or the Fenton Agreement. Just bearing in mind, it says the Treaty of Waitangi because within the legislation, the Local Government Act 2002, Section 4, states, in order to recognise and respect the Crown's responsibility to take appropriate account of the principles of the Treaty of Waitangi and to maintain and improve opportunities for Maori to contribute to local government decision-making processes, Parts 2 and 6 provide principles and requirements for local authorities that are intended to facilitate participation by Maori in local authority decision-making processes. So it's about giving effect to the principles of the Treaty of Waitangi until amendments are made so it becomes clear that it's Te Tiriti o Waitangi. So we acknowledge that there are differences between the Treaty of Waitangi and Te Tiriti o Waitangi. Also acknowledging the generosity of mana whenua and te arawa in terms of granting the Rotorua Township for the purposes of establishing.
Okay, the next stage, thanks Guy, consultation of the proposal. So we need to, you needed to come up with a initial proposal. And there were numerous workshops carried out with elected members to look at an initial proposal to go out for consultation. Following these workshops, the initial proposal that was decided to go out for consultation was Emir, elected at large, one Maori ward with 2 seats, one general ward with 4 seats, 4 at-large seats, and the retention of the Rotorua Lakes Community Board and the Rotorua Rural Community Board.
And there were significant themes that arose from the submissions and the consultation process. One of them being equity and equality. This notion of everyone being equal, everyone should have the same, regardless of what electoral role you're on. And if we think about the concept, the idea of the establishment of the Rotorua Township and the generosity of Ngāti Whakaue in gifting the land for the establishment of our township, you might not be aware, but there's this concept in Te Ao Māori called tuku, which is very different to koha. So we understand koha. Koha is a gift that you give without any expectation of a reply, a response. Okay? Tuku is a very different concept. Tuku is same thing, gifting or granting, but there is an unspoken expectation that there's going to be a response. So it's tuku atu, the response is whakautu mai. Okay? Utu being the concept. There are some sort of interpretation of what utu means, and it's usually about an eye for an eye. However, in this context, utu means a reciprocal response to equal the balance. Okay? So, in terms of the theme that's come out of this, is that, okay, Te Arawa gifted this whenua for the establishment of a township. A response could be that the number of Maori seats be equal to the number of general seats. Okay? That's equality. Okay? That's a reciprocal response to the generosity given by the iwi. Okay? Which also aligns with one of the other themes that came up was the Treaty of Waitangi. Okay? Which was a partnership between 2 parties. Okay? Tangata whenua and tangata tiriti, or Maori and the Crown, or non-Maori. It was very consistent in the feedback in terms of making sure we give effect to the treaty or te tiriti o Waitangi. Co-governance was also one of the themes that came out in terms of arrangements for joint decision-making between iwi and or other groups, central government and or local government, which aligns with the principles of te tiriti o Waitangi. There was also inclusion of a rural ward was raised in terms of effective representation of the rural voice at the decision-making table. Also, there was a strong theme in terms of equal suffrage. In particular, universal suffrage provides the opportunity for qualifying citizens the right to participate in the voting process. Okay? Everybody has the right to vote. However, suffrage does not apply to the voting criteria, such as how many votes each person has. Proportion of votes based on population, that's proportional representation. Okay? So it's about giving everyone the opportunity to participate in the process.
So the question then for yourselves is on taking on board all of that, all of the submissions and the themes that you've heard coming through from those, is where do you go to from here? So you will recall that there was a forum for yourselves to reflect upon some of that initial feedback that had come in. And there had been a question put to us as staff to see whether a desired model that meets your requirements and also responds to the strong messages that were coming through in the submission feedback. That desired model was based around an ability for one mayor elected at large, a Maori ward that had 3 seats, and a general ward that had 3 seats, and then 4 at-large seats. The continuation of the Lakes Community Board and also the Rural Community Board. So what would that mean in terms of voting and being able to elect a council? Voting would look like this. If you were on the Maori electoral roll, you could vote for 3 Maori in the Maori ward and for 4 at large. So you would get a total of 7 votes out of 10. And if you were on the general electoral roll, you would vote for 3 candidates standing in the general ward and again 4 at large. So again, you would have 7 out of the 10 votes. Everybody, regardless of what role you would be on, would have the same amount of votes and all have the same opportunity to vote for the people representing you and representing Rotorua going forward. So those guiding principles have definitely been met in a model such as this, that there is equality between the Maori ward and the general ward, and there is the same and equal number of votes to elect a council to best represent Rotorua. However, there's a but with this. This model, under the current Local Electoral Act guidelines, is not permitted. And it is not permitted because of the equation that needs to be used in calculating the total number of Maori seats. A way forward, and if the council wishes that parity is what is desired, there is a way to create parity, but it does require a reduction in the total number of ward seats and an increase in the seats elected from the district as a whole. This model that we've got up here now on the screen is the only lawful model available to council at this time that meets the Local Electoral Act guidelines and also meets the guiding principles. That model would be one mayor elected at large, a Maori ward that had 1 seat, and a general ward that also had 1 seat, and 8 at-large seats. There would be the continuation of the Rotorua Lakes Community Board and also the Rural Community Board. So in terms of voting, it would look like this. If you're on the Maori electoral roll, you would get to vote for the 1 Maori ward standing councillor and 8 at-large councillors. So there would be a total of 9 out of the 10 votes. If you are on the general electoral roll, you would get to vote for 1 general ward councillor and 8 at large. Again, a total of 9 votes out of 10. So you can see there with this model, which does meet the requirements of the Local Electoral Act, everybody has the same opportunity to vote for the total number being 9 for who would make up a council going forward. The question, when we put the 2 models side by side, the initial model, as you can see up there, shows that if you are on the Maori electoral roll, your total number of votes would be 6 out of 10, compared to if you are on the general electoral roll, 8 out of 10. Compared to an alternative model, which is lawful and does meet your guiding principles, everybody would have the same opportunity and be able to vote for 9 out of the 10 members. Just going back. So the question now sits with the committee to take on board all of the feedback, consider those guiding principles and determine which model going forward best represents Rotorua for the next elections and the one after that. We're happy to take any questions.
About that, yes. I think I'll come to you first, Your Worship.
Thank you for that overview, and also thank you for seeking clarification around our desired model, which felt good, but I'll get to the question. And the question probably is to you, Lachlan, when you talk about the Electoral Act and their guidelines. If we went with our desired model, in the Electoral Act, does it say that we must give effect to the representation formula? Or is it just a guideline?
Thank you, Your Worship. Firstly, can everyone hear me okay?
Yes, I think so. Thank you.
Thank you. Morena, everyone. The short answer to that question is that this is a legal requirement. So it arises under the Local Electoral Act, which has a mandatory requirement for you to apply a formula to the number of Māori ward seats that will eventuate if you choose to have a Māori ward. And that formula is set out in the first schedule to the Local Electoral Act, and it is mandatory. So if you were to follow the preferred model of parity, which is the 3-3-4 model, you would expose yourself to a legal challenge. Now, it's important to bear in mind that once you make this decision today, it gets publicly notified, and there is a next step, which is for any party that wants to challenge and appeal that decision to court, it can do so. And you'd need to be aware that if you were to pursue the 3-3-4 model, it doesn't comply with the formula, and it would provide a grounds for someone to challenge the decision.
And can I ask Madam Chair there? So what legal access have we got to change? Is it to do a members' bill to get that Electoral Act changed to better reflect what our rohi has told us?
Yes, so my discussions with Chief Executive and with Una have been along those lines, in the sense that there's really two parts to the legal advice. One is to try and find an avenue for you today which allows you to make a decision which is lawful but which achieves parity, and the formulation of the calculation that has been presented is the 118 model, and that is lawful. It is in accordance with the formula, and you can pass that resolution today in the knowledge that you are doing so lawfully. Then there's a longer term play, really, which is how do we go about resolving the problem with the formula in the Local Electoral Act. And that can play out in a number of ways. One way that's very targeted to Rotorua would be for a local bill, which would be a bill that would be formulated and presented to the Minister for Local Government, which would be targeted at Rotorua and would basically create a specific set of provisions which could accommodate your wishes going forward into the future. And that's something that could be pursued. It may be that once the Minister for Local Government understands the problem that's being presented, that she may consider that this issue doesn't in fact best suit a local solution for Rotorua, but it may be a nationwide solution, in which case a local bill would turn into a bill of parliament. So there's a short-term play and there's a long-term play to solve the problem.
Thank you. I think, Lachlan, that what you've just mentioned about the local bill, was that similar then to what happened with the Bay of Plenty Regional Council many years ago when they introduced their Māori wards? I suspect it was the same thing. Do you remember?
I'm not completely au fait, but I understand, yes, that's right. It was a local fix to a local issue.
Thank you. Thank you. Yes, Your Worship.
That, Lachlan, it was because it was regional, it wasn't through the TLA representation, so it was a Bill of Parliament.
Right.
Yeah.
Thank you. Mr. Thomas.
Thank you, Madam Chair, and through you. And my question sort of follows on from the Mayor's questions in a similar vein. although I was wondering the feasibility of us putting to the Commission the, as you say, unlawful model, the 334 model, with a fallback of the 118 model. And the reason I'm asking this is that the Electoral Act is out of date. It does not reflect trying to meet the issues of the Treaty of Waitangi or co-governance, and we have an opportunity to force this realisation on New Zealand and to lead New Zealand in it. So I wonder if we should be putting forward our preferred model with a fallback that the Commission can throw that out and go to the 118 or the 246 model, 244 model. So I'm just wondering if that's feasible. And also my other question is, at the last electoral review, the panel that came up with our options put to Council, and Council accepted, making a recommendation, we knew it was non-binding, for the Council, the incoming Council. I'm wondering if that is a feasibility for us to do again, and also stress the importance on continuing the role of Te Tātou Aotearoa on the substantive committees and just reinforcing that importance to an incoming council.
There's a few questions in there, and I'm not sure I'm the right person to answer all of them, but I will just address the first point, which was the question of whether it could be appropriate to pass a resolution for the model that you know is unlawful with the fallback of the lawful option. I can't recommend that as an approach simply because knowing it is unlawful, I mean, it's inevitable that it would be overturned by someone if they wanted to challenge the decision, and inevitably it'll be overturned by the Commission. So I think that if you want to make the point that the appropriate way to deal with it is to pass a resolution which is lawful, but to pass that resolution with a very clear message that needs to be accompanied by the decision and sent to both the Commission and also to the Minister for Local Government to say that this is very much what might be considered the second best option for Rotorua, and it does not reflect the will of the people. And that is a problem with the legislation, and so urgent change is needed. So I think you could pass the appropriate resolution, which is lawful, but with some very strong messaging.
Yes, Councillor, thank you.
Madam Chair, could I just have a follow-up
Yes,
question?
certainly.
Just with going for the option of perhaps a local bill or even a parliamentary bill, what sort of time frame are those? Is there any possibility, if we were going down the path of a local bill, that could come into force in time for the next year's elections, or really these are actually long-term solutions and we're looking 6 years out before we could implement anything?
Yeah, I think that's a very good question. I think the timing of the fix, the long-term fix, is absolutely critical. Obviously, and your question, I think, it contains part of the answer. If we cannot achieve a resolution through a local bill which addresses the problem with the Local Electoral Act in a timely manner, you will be forced to implement the organisational structure that you've promoted, which is the 118, at least into the next election, and based on the current law, into the following election as well. So a 6-year lag period before you get a fix, which clearly would be, I imagine, politically unacceptable to you. So the strategy with the local bill would be to make urgent work of it, with a view to actually having the legislative changes implemented, if possible, in time to implement prior to the next election, but certainly not to see the 118 model carry over into the following election as well. So I don't know the answer to the timing, but I understand acutely the urgency of a fix.
Thank you, Lachlan. Where am I? Councillor Donaldson.
Thank you, Madam Chair. Through you, my questions are along the same, in the same vein as Mr. Thomas, and my understanding is that the Local Government Commission has already signalled it would not countenance the 334 model. So, you know, that's not something that we could pursue today. But my question is around the structure of the recommendation before us today, Madam Chair. We have Part 4 recommending to Council that the CE pursue statutory reforms, if possible, prior to the 2022 election. So, in the event that today either 2A or 2B was recommended to Council and Council adopted it, and the CE was successful in achieving a change in legislation prior to the 2022 election, does that mean then that that Council could unwind the model that's adopted and go with the one that's set out under paragraph 3? That's my question.
Again, it's a very good question, and I think that really comes down to the nature of the legislative reform. So, to a certain extent, we get to hold the pen, and if there needs to be some kind of transitional provision, which means that there is the ability to revisit one of the models that you adopt today, because the legislative reform is secured prior to the 2022 election, we can build that kind of mechanism into the legislative reform to enable you to do that. So you don't need a resolution necessarily to that effect. We would build it in and bake it into the legislation itself.
So can I, if I understand you correctly then, if we voted on a model today, but we pursued a reform, electoral reform, that could be applicable to us next year prior to that, that means that we could then be looking at another model altogether. Am I clear on that?
That's right. I mean, depending upon how quickly we can move with the legislative reform and implement it, there is the potential for you to once the bill is passed into law, revisit the representation model that you adopt today based on the new legislation.
I see. Thank you. Your Worship, can I ask you a question? With your experience as a Member of Parliament, what's the likelihood of a local bill?
Well, Lachlan knows local bills are considered every second Wednesday, and local bills do get a better hearing than a government bill, which goes into an order of priority set by the Leader of the House with Cabinet. So local bills get more attention, actually, and members' bills, if you looked at that, are picked out of a ballot,
yes.
Literally a biscuit tin. So that's a very broad chance, but a local bill is probably the best way to go.
Thank you.
And Lachlan should advise legally, but often there's a shortage of local bills, so they just get rolling.
Thank you. Well, that's very interesting. Thank you. Now, Mr. Bersini.
Lachlan should affirm that, really.
Yes, I can. I mean, I think that's certainly my understanding of the pace at which the bills can move at. So there is, it's not, in other words, it's not pie in the sky to suggest that we couldn't pursue and achieve legislative change in, say, the first quarter or first half of next year.
Thank you. Well, that's very comforting, actually. Thank you. Mr. Bersini Tule.
Kia ora, Madam Chair. From my understanding, Minister Nanaia Mahuta's intention was for greater Māori participation in local government, yet 1 out of 10 seats doesn't inspire any great hope for me. So how is Model 2A equitable for Māori? That's my first question. And the second one, with the 434 model, who might challenge? We can't put it up because someone might challenge. Who? The community and Te Arawa have supported this model. Who might challenge? The council?
Other submitters, anybody.
other submitters.
Thank you. Now, your question, you did ask a question there of first one.
How is Model 2A equitable for Māori?
Thank you. Did you hear? Oh, yes, perhaps we put the model back up. The question was asked as how is Model 2A equitable? And I presume one could say it's equitable because currently under the current regime, we've got 4 Māori sitting at the table now. So why would that not continue under the Model 2A? You would have a Māori seat, but it could also be that other Māori, so that could be an argument. Did you want to Lachlan, did you want to, it's around the...
It's the 1-1.
On behalf of 30,000 Māori voters, how is one seat equitable?
Well, I can explain the 1-1 simply. There's, I think, the report that you have at paragraph 5.4.1 and 5.2.2. I think there are some calculations that are set out. But in short form, what it's really saying is that under the formula that's been required of you, the formula requires a calculation which is based on the total number of people which are on the Māori electoral roll and those that are on the general electoral roll. And when you apply the figures that are provided, which in this case is 21,700 people on the Māori electoral roll and 55,600 on the general electoral roll. When you apply those figures to the formula, if you are going to pursue 6 ward seats in total, you are obliged, based on the formula, to split those 6 ward seats to 4, 2 to the Māori roll, 4 to the general roll or the general ward. So that's what the formula requires of you if you have a total allocation of ward seats of 6. Now, the only way that I can get the formula to work where you comply with the formula and achieve parity in the number of seats is if you reduce the total number of seats in the ward seats to 2, which gives you, under the formula, ultimately through some rounding mechanisms which are required under the formula, gives you a split of 1-1. So the only way that we can achieve compliance with the formula and parity in the total number of seats that are voted for is if we reduce the total ward seats to 2. And that's all set out in the report. It's a bit painful in terms of the mathematics, but that's the summary of the position.
The complicated mathematics starts us at 2, but because we're rounding down, Māori get 1 kilda.
Thank you. Oh, Jeff, did you want to? Sorry, you just take a comment from the CEO.
Can I just to draw your attention to this question of parity, and I think it's an interesting one. The question is having an equal number of votes important? And that's really not the purpose that you're trying to achieve. Although it's an important goal, the end point is actually each person who votes having the equal opportunity to elect a council which is truly representative of their views. So everyone has the same opportunity to elect a council which they feel will represent their views. I think that's just drawing out a little bit that principle of why is parity actually important.
Thank you, Jeff. Councillor Maxwell.
Keeping it to a question, Lachlan, can you recall some many years ago we did put up a Rotorua bill and that was, and it came before an election that was coming up for this council regarding 1.5 kilometres away from Pahutu Geyser. and it was taken out of the hands of council, and the bill went through Parliament, and it happened quickly. Do you recall that one, or maybe that we can find some more information on that? But that was a local Rotorua bill, and I just want to hear what you've got to say on that one.
Thank you, Councillor. No, look, I'm not familiar with that specific reference that you've made there, but I can certainly track down the history of it, I'm sure, and find out how it worked its way through the legislative passage. As I say, the position, in my view, is that we do, with the local bill, have, as Her Worship has indicated, a reasonably speedy avenue compared to some of the other avenues that bills have to sort of wind their way through. So I come back to that point that I think that it's not unrealistic to expect that we could potentially get a result if we pursued this by the first half of next year.
Thank you. Councillor Wang.
Thank you, Madam Chair. My question was around, so option 2A that we have currently, which is the 1 Māori seat, 1 general seat and 8 at-large seats. Throughout the submission hearing and throughout the workshops, the plus or minus 10% rule was consistently brought up, and that was the argument that was also used with the rural ward that was brought up by the rural community. But with the 2A option, 1 Māori seat, 1 general seat and 8 at-large seats, effectively the 1 Māori seat would represent 21,000 and the 1 general seat would represent 55,000 in population. So I'm just wondering, because on the document says that under this provision, membership of wards is required to provide approximate population equality per member, and so all votes are approximately equal value. So the plus or minus 10% rule, unless there are good reasons to depart from this requirement, and so I'm guessing that that good reason would be because we're trying to achieve parity.
Oh, I can step in and answer that one. The plus or minus 10% doesn't factor into this model and doesn't need to. The reason being for that is that you are talking about a Maori ward that covers the entire district and a general ward that reflects the entire district. So that plus or minus rule doesn't relate in a model like this, and we don't have to use that one.
Do you want to come in at this point, Your Worship? Oh, thank you. You've finished, have you? Thank you. Look, I'll go to Councillor Tapsell.
Thank you. It was just a simple question. The alternative model is quite new to a lot of people and would be new to all of the submitters. I appreciate it's come back from the feedback that's been received, but my question is, was there a discussion with Te Tātou Aotearoa or our iwi partners in general about this? Because I, for one, am quite surprised and a little disappointed at the suggestion of only allowing one for the Māori electoral roll. It's a bit hard to talk about parity if it doesn't make sense. And for our iwi partners, I think, as we're hearing through Mr. Biasini Tule, it's quite unpalatable to reduce down to one. So have we had just a simple discussion with them before bringing this model to us at the table today?
Thank you.
I think what we've got here through you, Madam Chair, is a rather restricted time frame in that you gave us direction at a forum where Te Tātou were at around looking at the ability for moving down a direction of 334. The time frame that we've had to do that, we haven't had direct conversation with Te Tātou in putting forward the alternative model. hence the reason the paper has been put forward as this isn't a either or. We've put it forward to the entire committee in terms of what is possible, based on the fact that right now the option of 334 can't be achieved in based on the requirements and the time frame. So what we have brought back to the entire committee is the ability for the council, the committee, to have those discussions on what going forward best represents Rotorua.
Thank you. I'll carry on. Councillor Kai Fong. Oh, yes, certainly. Councillor Kumar.
Thank you, Madam Chair. I'll keep it very simple to what I understand. And through all the workshops and everything, the one thing that was loudly, and the one thing we've taken a lot of pride in, is that we are a partnership with Tato. And I know the Minister has an appetite for, she wanted Maori wards. So we went and consulted. Tato went out wide and consulted. And they gave a model. And they were very staunch that they wanted the guaranteed seats. And here we are reverting to another model. So where is the partnership working over here?
Which is similar to what actually Mr. Versini Tuli has asked. Yes, Your Worship.
Just a question, Lachlan, because when we apply the formula, that's where we've stumbled, really, but because we have to. But could you talk about the Maori electoral options as applied to the Local Electoral Act? Because most people went on the Maori roll not for local body elections, but for the general elections. And now we're stumbling with an anomalous model because we're trying to apply a formula that doesn't sort of fit for this contemporary world, and as other council have said, doesn't feel fair. Would that be able to be changed in the step up to a local bill as well? Because the local electoral option doesn't consider whether you go on a Maori roll or the general roll, not for local elections.
No. I mean, that's part of the problem, is that local government effectively has to inherit the central government electoral model and then fit it into this formula that's been imposed, and it produces these kind of anomalous results. So I think that's part of the complaint and part of the concern that we would want to have addressed. I mean, just in terms of the general sort of consultation issues, and I can't speak to all of this, but just in general, in terms of the legal elements of it, remembering that you did go out in terms of your initial proposal with a 2-4-4 model. Now that is legally compliant. But the problem with that is that it has this non-parity element to it. So the community is obviously clear that that is one option that is available to you, which has the benefit, of course, of allocating 2 seats to the Māori ward, but it has this problem with parity in terms of the total number of votes. That's obviously still an option that you could pursue, which is the initially consulted on option, and that's option 2B in the recommendation. But if the feeling of the elected members is that the parity point is so significant that you want to address it, the only lawful way you can address it, which complies with the formula, is to move to the 118 model. And if your community consultation and feedback was indicating to you that parity was a critical factor and that it was in the balance more important than the total number of seats allocated to the Māori ward, then you might favour the 118 model as an outcome. But that's ultimately a decision for you.
Thank you. Councillor Kai Fong, how are you placed? Thank you.
Thank you, Madam Chair. Just following on from Mr Biasini Tule and Councillor Tapsell, and it is disappointing that we didn't consult with Te Tato Aotearoa with the new recommendation, but maybe this is more a question for Te Tato rather than for Una and Rick or Lachlan, but as I understood it, I know we're talking about parity of voting, but the Te Tato recommendation originally was that effectively you wanted to guarantee Māori seats sitting around the table, so you were prepared to forego the opportunity to vote if you had a guaranteed number of seats. So that would take us back to the initial model if we're now looking at what is the best of the two scenarios that are now on the table. Would that be a fair summation?
We started with no assumptions. We were just given a process, and it was, when we came back with the feedback from Te Arawa, it was for 3 seats. And then when we actually went to Ngāti Whakaue, it was based on 50-50 with the township agreement. So 5 seats or 3 seats was something that I think inspired some hope. To find that first we hadn't been included in any discussions post those workshops, and then to be landed with a model that reduces us to 1 is insulting, actually.
Yes, you were, well, certainly Te Tato was invited and was present at most of the workshops that we were held prior to us putting our first paper together.
That workshop for staff to meet so we could discuss, but there's been no discussion. And to be quite frank, Te Tato is next door. You've had how many days in a week, or a couple of days will be in a week. There has been ample opportunity for Rotorua Lakes Council to discuss with Te Tato, and that has not been followed up. And we actually think it's deliberate.
Thank you. Would you like to respond to that, Una? Because as a staff member, you put all of our...
Yes, just to say there that, I mean, Te Tato o Te Arawa haven't been not consulted or anything in here. Te Tato are actually a submitter. So therefore, we can't go back and talk to a direction going forward with a submitter. Just like we couldn't go back if the Rural Board had put in a submission or the Lakes Board had put in a submission or any other submitter who has put a submission in. We don't go back and discuss with them alternatives or the direction or the legal advice that we have had in bringing back to you the direction that you as a committee had set us to go and investigate in the first place.
I thought we were a partner.
Well, you made your submission. You did make your submission, and therein lies a dilemma. Most of us sitting here actually know that when you put your submission in, then that really, I was going to say seals, not your fate, but yes. However,
that said, I've been kind of authorised by my rangatira to withdraw from this process because we do not feel like it's equitable or for Te Arawa, and we will appeal.
Yes, yes, Your Worship.
Shame.
I think that's a shame.
No, it's a shame.
But it's when a group decide to put in a submission, as you said, I totally support you.
Yes.
Others would have said, please come back to us too before you adapt a model. We need really level heads here about finding a way forward, an interim position that expresses parity, and then that step-up provision as a way of addressing the concerns expressed by others. That's elected members, and when elected members do a submission, they are not consulted back about any revised model.
Well, we don't give the opportunity to any other submissions, do we?
No.
So you're quite right, and I'm just sorry that people don't...
Point of order, Madam Chair. I respect the discussions that have been made, but the point was quite clear. It wasn't about discussions with Te Tato or Te Arawa. It was about discussions with Te Arawa as iwi partners, Tato. So when we've just talked about giving effect to the principles of Treaty of Waitangi, the Township Agreement and equity and equality, it would be reasonable for us to have a discussion with them, which is also why I asked the question, because this is very, very different to what what they had been told, what our community had been consulted on, and what they were expecting. So I can completely appreciate and understand the anger and upset that are coming from iwi at this stage for us to make this decision.
Thank you.
Would apply the same if we'd have gone back to submitters from Whakaui that suggested a co-governance model. It was inappropriate for us to do that too. They were submitters. We've just got to be really clear about when an organisation, and they are our partnership under Te Tātou o Te Arawa, that is not enshrined in the law, and they chose to submit. So we're in the same position of not going back to Whakaui, not going back to other submitters, Grey Power, anybody else who submitted. We've got to keep very clean hands about a process and find a fair and equitable way forward as elected members.
However, it is unfortunate. It is unfortunate that this has happened because we are in a relationship with Te Tātou o Te Arawa. It's one that should be based on trust. And I feel that that's unfortunate that this has happened. But that you are right. But we always say to councillors, be careful if you do want to submit. Oftentimes I've wanted to submit on something, but you don't, because you know that when it comes to the discussion, you really want to be here having your say, and it makes it very limiting. I am going to proceed to our next, where have I got our next? Do I have another one? Sorry. Oh, Mrs. Trumper. Sorry, Mrs. Trumper.
Thank you, Madam Chair. I just want to make a point first and just say the Rural Board work very hard with our community, and I want to make that point right now that we really want a rural ward. And when we looked at the new agenda and saw 118, conversations came back to me and said 117. 1117 would have been a really good option, and I know that that's probably been answered by Una already, that it took us out of the plus or minus 10% because of the general ward. But the question I have is, because we're here discussing a totally different model, would that model then have to be put out for consultation, or would new submitters have the opportunity to put in an appeal on this process if this model is adopted? It's really establishing whether the commissioners would hear from new submitters and not original submitters appealing.
Thank you. I'll let you answer that, Una or Lachlan.
I'll start it off and Lachlan can finish it off if I've missed anything. Whichever model you choose to take forward, and just to point out clearly at the moment, there are two options that you have in front of you, and you haven't yet decided or even have a motion on the table of which one to take forward. So again, we're just talking about and clarifying the aspects and I suppose the validity of the new model. If there is a case that you take forward the 118 as your final model, still only though, because of the process, it still is only those submitters who were part of the original process that will be allowed or permitted to actually provide an objection or an appeal to this model. And just clarifying that this model here, if you chose to take it forward, is a response to the feedback that's come in.
Lachlan, is there anything you wish to add to that?
No, that's captured the position. There is a, I'm just looking at the objection rights. So the appeal rights are limited to those parties that have been submitters, but there may be slightly wider objection rights if the decision is different to the initial proposal, which if you go with a 118 model, it would have differed from your initial proposal. There's a sort of a wider class of people that might be able to submit an objection on that basis. But generally speaking, the rights of appeal are limited to those that have submitted on the original proposal.
Thank you. Yes,
Chair,
Mrs.
I've just
Trumper.
got a follow-up question then, Beck, because in the representation review back in 2015, I know that an organisation didn't submit to the initial proposal but was able to speak to the commissioners, and I just wondered whether that was a consideration that would be going forward. So that was my reason for asking.
Sorry, through you, Madam Chair, I'm not aware of that one, so we'd have to look that up. Yep.
Thank you. Thank you.
Can I just be clear on the process for challenging the decision? So what would happen here is that the council would make its decision and would notify the Local Government Commission. If the Commission receives an objection or an appeal against that decision, the Commission then has to hear and determine that matter and make its own decision whether to uphold the appeal or the objection. And then the Commission's decision on that point can then be the subject of judicial review if a party is dissatisfied with the Commission's decision. So the first stage of any challenge would be to the Commission, and then following the Commission's decision, it would be a judicial review to the High Court.
It's quite a process.
Yeah.
Thank you. Councillor Bensley, then Councillor McPherson.
Thank you, Madam. Thank you, Madam Chair. The 118 model that has been put forward is the most, in my understanding, is the most legally compliant way to go. Surely we could have that second one Maori ward, one rural ward, and satisfy the rural community to the extent that I think if we don't have a rural board, we will be suffering some legal consequences.
We do have a rural board. Are you saying we don't have a rural representative?
I meant a rural ward.
Rural ward. I see. Thank you.
Through you, Madam Chair, we've continued to have a look at the establishment of a rural ward. The feedback from the submitters, I think, was from what I heard, and you may have heard differently, but there's this a distinction between the rural community board boundary equaling a rural ward or a non-urban ward. And I think there needs to be, going forward, some more work on that distinction. Because if the desire of the rural community is for a true rural ward that reflects the boundaries of the current rural community board, those numbers do not stack up. They do not meet the plus or minus 10% rule, which would come into play in this case. So we've tried to make it work. We've consulted with the Local Government Commission on the inclusion of a rural ward, and they have said that the deviation at this point in time is way too far out of that plus or minus to be considered a valuable part of the model.
Thank you.
Madam Chair, can I just add a comment there, because it arises from the question where I think it was framed in terms of the statement that the councillor made was that the 118 model is the most legally compliant. Can I be very clear? The original proposal, which was the 244 model, that is legally compliant. That is just as legally compliant as the 118 model. The point is this: under the 244 model, perfectly legally compliant, but it means that those that are voting on the Maori ward ultimately vote for less elected members. And that brings with it this concern about parity. If you want to resolve that parity issue, the way to achieve or solve the problem is to move to the 118 model. So both of them are equally compliant legally. One has a parity issue, the other solves the parity issue, but it comes with a trade-off because you reduce the number of seats in the Māori ward. So just wanted to make that perfectly clear for you.
Thank you, Lachlan, but it does maximise the vote for those Māori who are on the Māori roll.
The 244 model?
Oh, no, the 811.
The 811 model achieves absolute parity, whether you're on the Māori roll or you're on the general roll. Every elector will have the opportunity to vote for a total of 9 out of 10 councillors.
Thank you. That's very clear. Thank you. Councillor McPherson.
Thank you, Chair. Thank you, Una and team, and thank you, Lachlan, for your input. Much appreciated. Earlier in the questioning phase, the Deputy Mayor confirmed that advice had been received from the Local Government Commission, LGC. I wondered if, in formulating your advice to Council, Lachlan, you had taken that advice on board.
I'm not entirely sure what information from the Commission you're referring to, Councillor. There was, I think, a discussion document headed up guidelines for local authorities undertaking representation reviews from the Local Government Commission, and I have had access to those guidelines and have referred to those. But if there's anything more specific, I'm not sure that I've seen that.
Point of order, Madam Chair. Can I just
Yes,
clarify?
I think those are the guidelines that we all had access to.
Yeah, and Madam Chair, when we at the last meeting proposed the 334 model, we directed staff to explore with the Local Government Commission whether they were flexible on the rules under the Electoral Act, because it was raised by Una at that hui that we wanted her to go to the Local Government Commission, and that's why I asked the question today, what was the response of the Local Government Commission?
Thank you. I'm happy for you to answer that because it might help. Because that was a question, that's what we put to you. It wasn't put to Lachlan.
That's right, yes. So yes, you are right. So the direction at that forum was for us to go and seek advice from the Local Government Commission whether they would permit us to put forward a model on 334. They came back adamantly and said no. There's no provisions in the current legislation under the Local Electoral Act for them to accept that model. So based on that and based upon the very clear direction from yourselves around this desired model of 334, that's when we've started looking at, well, what can we do in order to challenge that and look at other, I guess, reforms in that may get us to that desired model state, and that's what Lachlan has discussed in terms of potentially going down a local bill and the likes there. However, at this point in time, we do have that time constraint as well over needing to adopt a lawful model by the 19th of November.
Thank you, Councillor.
Thank you. My supplementary, or my second question, is therefore, given the, I'm sure, highly nuanced advice from the Local Government Commission about the pros and cons of achieving compliance with regard to parity, and coming from interest groups that do not give such weight to parity but to other democratic values, can I ask if the advice from the Local Government Commission be made available to me and to other elected members to understand the nuances of their advice? Thank you.
Through you, Madam Chair, we had no written advice from the Local Government Commission. What we sought from them was if we put forward this model, would it be accepted? And they came back and said no, because of the rules of the current Local Electoral Act do not permit a deviation from the rules. This model here, the formula that Lachlan has stepped us through on occasions now, isn't met in that model, therefore they wouldn't consider it.
Yes, sorry, I should have been clearer. It's not so much the substance of the advice, but it's the nuanced nature of that advice. But you're telling me now that that advice was purely verbal from the LGC.
What's the nuance about parity that you're unclear of?
It's a different part of the argument. What I'm after is access, if I can have it, to that advice. If it's written, can I please have a copy? Can please all elected members have copies?
Thank you.
Thank you.
I think the response has been quite clear. Sorry, would you like to? Yes,
is it
thank
purely
you.
verbal?
Working? Yeah. There is no nuancing of this advice. If the model does not fit the requirement.
A point of order, Chair. Point of order. My question has been quite specific. Can I please have access to that advice, nuanced or otherwise? Can I please have access? Thank you.
Thank you. Sorry, you've just had that advice. You've just had access to it. It's been given to you by UNA. It's now been reinforced by, spoken to by our CEO. So you've had that advice. So I'm moving on. Thank you. Councillor Maxwell, did you have another question there?
That's bizarre.
Thank you. Look, Una, I'm sitting here thinking about Te Tato or Te Aroa, and I'm just not quite sure about the, are they sure, or should we hear a little bit more about the process? Just so, and then I'm going to take a break. Okay. Thank you.
Thank you, Madam Chair. And I think...
and the reason, can I just say, Una, the reason I say that is that there will be people watching, and of course we would want to hear that as well, to make sure that we did undertake a process that we can stand behind as well.
Mm-hmm. So through you, Madam Chair, and I think it is referred to actually in the full paper here, is that the paper in your agenda item does refer you back to the paper of the SPNF committee on the 26th of August, which outlines the whole process to getting to a point where you adopted an initial proposal and went out and consulted on that. But casting your minds back, you will recall that earlier on in the year, a bill was introduced by the local government minister for councils to be able to make a decision around the introduction of a Maori ward. Te Tato undertook that consultation with Te Aroa and came back to yourselves with support for the introduction of a Maori ward. And this council adopted that at the time, and it is disclosed in that paper of the 26th of August. It states very clearly that Te Tato and Te Aroa supported the introduction of a Maori ward, but had yet no opinion or direction on the number of seats that should be within that ward. So in making a decision on the introduction of a Maori ward, then you as councillors undertook 4 forum, of which Te Tato were involved in, plus our community boards, and you all looked at the various options, of which there were many different models that you considered, and you had a look at the pros and cons of all of those different models, and gave us direction on which model to bring back to you. That model that came to the 26th of August was the model that is up on the screen there, detailed as the initial model, and this is the one that went out for a 4-week period of consultation. During that 4 weeks, we received a number of wide-ranging pieces of consultation, feedback. Many different entities were represented, many different individuals were represented in that. And as you saw today, what we have tried to do as the project team have synthesised that feedback to you in those themes and tried to match them up against the guiding principles that you yourselves had adopted at the very initial stage of the representation review. Following on from receiving all of those submissions and listening to the submitters that came in and spoke to their submissions, you set us quite a clear direction in trying to work on a model that did have parity. So the option of could there be equal numbers of seats between the Maori ward and the general ward, and what would that look like? That desired model was that 334, which we've then asked the local government commission whether they would support that. They have said no. We have then continued to work on a lawful model that shows and reflects back to you the parity between the Maori seats and general seats, and also, more importantly, provides every person in Rotorua, every voter, the opportunity to vote for the council that sits around the table and represents the needs and interests of Rotorua going forward.
Thank you very much for that, Una. Thank you. I think that was good to have that. I am going to, I think we'll take a 15-minute recess now, thank you. We'll take a 15-minute recess and come back at 10 past 11. Thank you. I'll just, perhaps, yes, I will. I'll ask for a mover and a seconder, please. Thank you. This is for the motion. And I'll put that, I'll just read it out so that everybody's clear about this, and then we can open it up for discussion once I get a mover and a seconder. So it is up there. That the committee, after considering, I'll put it here, I'll read it here, after considering the submissions and requirements of the Local Electoral Act, recommends to Council to adopt a final representation model that consists of one mayor elected at large, one Maori ward with one seat, one general ward with one seat, 8 at-large seats, a Rotorua Lakes Community Board, a rural community board. Or B2, that the committee, after considering the submissions and requirements of the Local Electoral Act, recommends to Council to adopt a final representation model consistent with the initial proposal that consists of one mayor elected at large, one Maori ward with 2 seats, one general ward with 4 seats, 4 at-large seats, a Rotorua Lakes Community Board, a rural community board. So do I have a mover and a seconder, please, for that motion? Sorry. Oh, sorry, that's right. So the mover has to indicate which option they are. Thank you. Yes, you. Is that? Would you? Thank you.
Yes, Madam Chair, through you, I move Model 2A, and I will speak to that after that's
thank
been
you.
made.
So, and we do have 3
and 3 and 4.
3 and 4. Thank you. Well, I'll read those out as well, so that we can just commence the discussions. That's 3 then, that the committee notes that despite the 2 recommended options, a different model consisting of 3 Maori ward seats, 3 general ward seats and 4 at-large seats is the preferred model for representing the best needs of Rotorua in accordance with the principles of the Local Government Act and the Treaty of Waitangi, but that this model is not enabled under the current legislation. And 4, that the committee recommends to Council that it instruct the Chief Executive to pursue the necessary statutory reforms or other means by which the preferred model can be adopted by Council at the earliest possible time, including, if possible, prior to the 2022 election. So, Your Worship, you're moving that, Your Worship,
2A, 3 and 4.
2A, 3 and 4. Thank you. It has been moved. Do I have a seconder, please, for that? Thank you. Oh, sorry, it was... Oh, thank you, Mr. Thomas. Thank you very much. Thank you. So it's now open for discussion.
Sorry, a point of order.
Yes.
Could I ask through you that we give consideration to splitting the motions, because 2A and 2B are clearly options that affect quite immediately what we're working on. Parts 3 and 4 are much longer term issues that require separate, I would suggest, determination. Could we consider splitting them?
As the mover of the motion, Madam Chair, I understand what the member's saying, but I see it as very integral to 2A that we at the same time must show some urgency about pursuing an alternative model legally. So I'm not prepared as the mover of that motion to have the motion split.
Right. So thank you for that. So we're looking at either the motion is supporting 2A and 3 and 4.
Order.
Yes, thank you.
Sorry, just to double check the process, but then if the motion is then lost, does that mean that we also lose 3 and 4? Yeah, which yes. I think, so by process, technically we should split them up? Because, so when it goes to the vote, we might say, no, we don't want that, but then technically we would also be saying, no, we don't want 3 and 4 when we're only saying we may not want 2A, we want 2B instead. And then we can proceed to put forward 3 and 4. Just double checking.
Yes, thank you. We'll check that because it does actually sound reasonable. Thank you.
I think, just looking at Una on this one, you've got two options. You can either hold them together at this particular point. If this is lost, then effectively you can move a second set of motions, which would be 2B, 3 and 4.
Yep.
Oh, I see, right. So it could be lost in the first round and come through in the second, and 2 and 3 can be, 3 and 4 rather, can be included. So then the motion would remain as you've suggested. That's fine, thank you. Now, it was moved and seconded, wasn't it? That's right. Moved by Your Worship, Mr. Thomas, thank you. So we'll now open it up for discussion, please. Thank you. Councillor Maxwell. Sorry, yes, beg your pardon. Yes, sorry.
As the move of the motion, I do wish to speak to this, and this was a surprise to us all. It was a surprise to us all, but when you sit and consider it in terms of what our preferred model was, it's not able to be implemented, and it would be subject to a legal challenge. I think what we're all forgetting is that we have a partnership that we value. We have a partnership, Te Tato Aotearoa, that is not enshrined in the law. That could be changed with an incoming council. We got the opportunity to consider a Maori ward, and we, with our appetite here and of partnership, took that up, and that's what we're struggling with today. I liked our preferred model. We can't do it. So it's been very clearly fed back to Una that that is not possible. But we got a surprise when we saw, where is the equity? Well, to me, I see it as Lachlan has explained very elegantly, 1 Māori ward, 1 general ward, and 8 at large, which means regardless of the role you're on, you have an equal vote, 1 plus 8. And therefore, it's simple when I look at the principles that we undertook to guide us on what model we take out. It is simple. It is equitable, and it provides equity. But I can't put that out without speaking strongly to 3. And that's why I don't want it decoupled here. Because point 3 is to show that as a council committed to our long-term future and our grandchildren and our partnership proposal, the electoral law is fundamentally flawed. And it's fundamentally flawed for the reason that when you choose which role you're on, you're not able to re-choose for local government, and that needs to be changed. So I really have to emphasise that that must be done at haste, and it would be wonderful with the full support of council. So I go back to keep it simple, even though it's a shock, and we've seen that this morning, sadly, that it was a shock. And that is a lesson for us all about when we're elected members. If you choose to do a submission, then that is difficult for you to be consulted on about changes that occur as we instructed the governance team to follow up. And they did. They went to the Electoral Commission, and our preferred model that felt good for us, some of us, anyway, I'll speak for myself, it doesn't work. So this is simple. It's an iterative process. If we can move with a local bill with haste, we will be leading the way in the country. And that's what we forget in all this emotion, that actually Rotorua will once again show that we're moving towards equity, and we're proud of it. But I want all our mokopuna, and I want those that are on the Māori or the general role to feel they have an equal vote. And the option as proposed in 2A is the only way that we can all get that equal vote. So I will be voting in support.
Thank you, Your Worship. Thank you for that. Mr. Thomas?
Thank you, Madam Chair. And look, I just want to support the Mayor's comments there. I too absolutely support the 334 option that we cannot have. I think it would be absolutely groundbreaking and leading for New Zealand. I think it's a really strong statement that Rotorua values co-governance with our partners, with Te Arawa and with all Maori in the area. I look at both these options and I think they're both poor options actually compared to 334. However, I think the option 2A, which is 118, best retains the intention of the 334. So the equal vote, whether you're on the Maori roll or on the general roll, you have the same rights, you have the same number of votes. And I live in an area where we have a lot of people on the Maori roll, and I had a steady stream of people coming up to me at the last election where they were saying, gosh, I can't vote for Katie Paul on the general roll. Why? Why has she been left off my list? And there was a real lack of understanding that if you were on one, you lost the other. And I think we would get a lot of that with any other version there where there's an equal number. I think of two sisters, I think of two partners, I think of two friends. Why should what role they're on determine what influence they have on the elected council in Rotorua? I think this has all come about because the Electoral Act fails to recognise co-governance, fails to recognise the right of Māori to have their equal say in local government democracy. And what we're doing here is actually pointing out the failure in that Electoral Act. I do hope that we work with urgency to put forward a local bill, and I hope that we're successful on that. As I said, I find it hard to support either of these options, but I do feel on weighing everything up, option 2A reflects more closely what we're trying to achieve as we would like to be able to do if we weren't stymied by the Electoral Act. Thank you.
Thank you, Mr. Thomas. Thank you, Councillor Maxwell.
Thank you, Madam Chair. First of all, before saying what I want to say, Aroha, sorry that Potawa has had to leave. It was only question time. You know, I was hoping he would stay for the debate and maybe he'd see that it may go the way that this motion is going to go, which I'm sure he would have supported. But I wholeheartedly support the motions that have been put forward, especially with number 3 added to it, 334. It mightn't be legally compliant at the moment, but how things move so fast in Parliament, even the Maori wards came up on us so quickly and we had to act so quickly. But I also want to thank our team that have been at the front. They've presented a good report from our last meeting where we were very warm to the idea of supporting the things that have come out with parity there, 334. So thank you, Una, Rick and Kihi. And also, Kihi, it's not easy at times to be sitting there as tangata whenua he Maori. A kumara doesn't talk about its own sweetness, but you expressed especially about Te Arawa's generosity and Ngāti Whakaue, especially their generosity. And they gave very good presentations here. I acknowledge in the submissions from Ngāti Whakaue their desire to try and get the parity equal. Mind you, 141 years ago when the township was set up, it wasn't equal then. It was 2 and 1 Maori on there. But hey, that was a start. But let's, and I think Phil touched on it a bit earlier, we have a chance. Rotorua is unique, and especially in local government. I touched on the geothermal one, that we sent a local bill to Wellington, and it came back pretty quick, and if I can remember, before the election came, because every one of us would have been turfed out of this, who were on council at the time, if we didn't get that bill through. I hope that Nanaia, the Minister, moves on this quickly and looks at our desired model, our preferred model, and hopefully that's the one that we can pursue with. But this is the next best, the 118 at the moment. So yeah, I definitely, and it's something that I noticed in here. There was also it was acknowledging one of the parity and equality, equity, the principles of redress. It's a time to put some of the things right. For a long, long time, things have been not as good as it is the current council now. I've been quite proud of the council we have at the moment with the diversity, but it's I think it's time that we can get the principle of redress also done as well. Thank you, Chair, and I wholeheartedly support the motion. Kia ora.
Thank you, Councillor. Councillor Yates.
Kia ora, and through you, Madam Chair, and apologies for lateness this morning. Firstly, I'd like to talk about the process. Ka tangi toku ngā kau mo toku whanaunga po taua I tēnei ata. Unfortunately, yet again, our processes have perhaps been to the detriment of his understanding and te tatau's understanding as to their responsibilities here at our table. And ka mihi atu ki a koe kepa, kei te mohi ahau, kei te noho wahangu koe I tēnei wā. So I also acknowledge the kepa here as well this morning. But process has been a big thing for me this morning, albeit arriving late. I came into the live action. And it broke my heart to see my whanaunga feel so aggrieved at what he was feeling and observing. But as our Mayor Stevie has stated, it's our process that we need to stick by. So, kai runga I tērā he akoranga. So within that there is learning, and hopefully from here on in, that learning and about processes actually extends to our te tatau whānau and knowing what they can and may not be able to say at our table. Secondly, we voted on a Māori ward. A Māori ward wasn't determined or didn't necessarily determine how many seats that would include. That would ultimately come at the discretion of our council. So yes, we voted on a Māori ward. Secondly, I'd like to talk about the fencing agreement. And within the fencing agreement, as much as I am a little bit disappointed to see that we are down to these two options, my preferred option all along has always been the 3-3-4, or at least looking at an opportunity where parity was paramount. It's not about the people on the seats, it's about the people who get to vote for the people on the seats. Parity for me is the beginning and the end of what the fencing agreement was constituted on. It was a gift by Ngāti Whakauē, who looked at partnership within our township, newly erected township. So that's about me summarising where I'm at with all of this. Although I will be supporting 2A, pretty much like the Māori wards, I would like to see more commitment from our council moving forward and fighting the bigger fight, because at the end of the day, we should be fighting this fight for the 3-3-4. It is our fight to be won. We've already demonstrated that we could do that by establishing and confidently establishing te tatau. Ka waiho aku koro ki kora, because it does get emotional, but it gets emotional from the point of view that we have an agreement with our mana whenua, tangata whenua, noko nei ake. And with that, being a Māori sitting here who has often been criticised as not doing enough for our people, ka hohāhau, because I look at our whanaunga here within our te tatau body of entities that support and partner with council. And within that, me mōhio koutou, kei te whawhai tonu, tātou, ahau, mō tātou. So, unless we get Minister Mahuta to change her mind rapidly, I will be supporting 2A, but reluctantly so too.
Thank you, Councillor Yates. Councillor Donaldson.
Thank you, Madam Chair. Yes, a real head scratcher, and whichever way we go, I think we're open to challenge. However, I too would like to acknowledge the presentation from the governance team this morning. I really appreciated Kihi's nuancing of the difference between a gift given in the spirit of tuku versus koha, so that spirit of reciprocity. And so I take that on board in my considerations. Also appreciate Lachlan being here to keep us on a legal footing. I think that's important for us. Looking at the two options, 2A and 2B, 2A for me reinforces the intent of paragraph 3. And I think, along with what my colleague Councillor Maxwell said, it's a time to stick to principles, to stick to our principles. And so those principles of fairness, equity, and keeping it simple. For me, 2A is, for the voter, is much simpler to get your head around, to know that you're going to get 9 votes, whichever role you're on. So it's less confusing for the voters. It's a bit of a conundrum for those who are choosing to stand as to whether they go for that one ward seat or not. So I think that's a bit tricky, but that's the problem for candidates. That's less of a consideration for me. I'm mindful also, and I too was dismayed by the reaction from Mr. Biasini-Toole. I thought it was unfortunate because when you think about Bay of Plenty Regional Council and the area and the population covered by the Waitangi constituency of Regional Council, that is a huge area, and so that's covered by one guaranteed seat, and so that colours my thinking as well. So all things considered, sticking to the principles that we were outlaid today by the governance team, I too are in support of the motion on the table. Thank you, Madam Chair.
Thank you. Councillor McPherson.
Thank you, Chair, and through you, also my thanks to the team for, over this period of time, helping us articulate the options and the values that lie behind those options. I'd like to, if I could, and I don't wish to offend anybody, but simply to respect the fact that the priority given to and the justification for the parity of outcomes argument, it backs up into partnership, concepts of partnership, and I acknowledge how well that's been articulated today. It also backs up into views on co-governance. I appeal to Te Tiriti and the Fenton Agreement. And I respect that this is the majority view here at this table. And I really appreciate the passionate advocacy in support of this particular view and how it backs up into the views of highly respected interest groups. A contrary view is that the parity of outcomes is at odds with the disparity of electoral populations. And it's salutary, I think, that this morning Te Tato, through Potawa, who was mortified, he was trembling with anger. Just like RDRR and grey power, he used the same arguments, that is the democratic entitlement of citizens involved in his population group, to ask for 3 seats. And the groups that I'm most familiar with, as interest groups, they take the same view. And we, that is the groups that I'm associated with, we don't have partnership status at all in this group. But the same logic, if you take it further, of enabling one group to achieve what they regard as their entitlement, would mean that the general electoral population would be given 7 seats. And that points to what we originally conceived as option 1, which is 3 Maori seats and 7 general seats. But that has been swept off the table through the force of the arguments behind the parity of outcomes argument. And it goes so far with many of my colleagues here today that it's okay to say that electoral law is therefore obsolete, but that comes from the same perspective, that partnership, that parity should outweigh, in my view, democratic values. Turning to the actual motion.
Yes, please do.
That's an unfortunate comment.
No, please do.
How tiresome. It's inappropriate, in my view, to bundle these together because they have got quite different sets of implications and should have been discussed in terms of those long-term consequences. With regard to 3 and 4, I think it's quite inappropriate for a group, electoral group, a voting group, to impose on the democratic discretion of a future council's representation review, which could take a very different position than the current set of considerations that we've been using. So, on the grounds of modesty at least, I think it would have been wiser to separate 2A and 2B from 3 and 4. That pretty much summarises my views, and I understand I might have upset and annoyed some of you, but please forgive me. And I have to say that I cannot, therefore, in good conscience, support any of these propositions. Thank you.
Thank you. Councillor Tapsell.
Thank you, Madam Chair. Through you, I would like to speak against 2A. I do not support it, and I support 2B. So when I voted against the Māori wards, it was because I believed it was a backward step for Rotorua. And as I warned, the introduction of Māori wards has restricted who people can vote for and disappointingly diminished the Māori influence in local government. So once again, I'm asking myself, what is the best for the people and what makes the most sense for Rotorua? And I am deeply concerned that providing only 1 seat for the Māori ward is a token gesture. And I believe that our residents would want quality over quantity, and allowing those on the Māori roll to have 2 seats at the table as opposed to 1, I think actually honours our moral obligation to give effect to the Treaty of Waitangi. And that's why I believe it's a token gesture to only give 1. I believe it goes against what Te Tātou o Te Aroa and wider iwi partners have asked us. And I also believe that by only giving 1 Māori seat and one Māori seat and 1 general seat, we are also actually diminishing the quality of candidates that may come through when they're given the option of standing for 8 seats at large or only 1 seat for general and for Māori. And can we honestly say that that's appealing for people to want to stand there? So for us today, and for my decision, it's what's best for the people of Rotorua and how can we ensure that they will have quality councillors moving forward, which is why I can't support a token gesture of only 1 Māori seat. And I do support allowing 2 and hope that we are able to bring in 3 at some stage. I'm grateful that we've got the recommendation to go back with 3. When we had the workshop and I asked, is it not reasonable for us to push for that? I appreciate the work that's gone into trying to do that, and while it is unlawful at the moment, I hope that this is a good example for the wider New Zealand, that actually if we are going to honour the reasons why Māori seats were brought in, then let's do it right and not in a token way for our community. So I will be voting against 2A and hope that I do get the opportunity to vote for 2B after.
Thank you. Thank you. Mrs. Trumper?
Thank you, Madam Chair. I'm also going to be speaking against option 2A. While it's transformational, it certainly wasn't consulted on out in the community, so they therefore haven't had an opportunity to provide input. And I think 2B, which was the initial proposal, is a far better sell for our community because they were offered an opportunity to be actually able to submit on that. There's been talk about 7.3. That was never a proposal. It was a thought and an idea, and it was an example of many models that were put out there for elected members to decide what we were going to have as an initial proposal. I think that we also need to bear in mind that with recommendation number 3, that I would like to ask a question with a local bill. How binding is that on subsequent representation reviews, and are subsequent councils able to manipulate those numbers so that we can get a rural ward? Because I think that a rural ward is definitely a community of interest, and it should really be looked at, if you looked at it as an independent director, they're there for a skill that isn't around the table, and it's really not a numbers base. But while we're working on numbers, we will obviously have to abide by the decision for 2022. But it was when the next representation review was up, whether there was an opportunity to revisit, because we know other councils actually make allowances outside of the plus or minus 10%. And I think we also need to be mindful that it is strictly a community of interest. I suppose the issue with rules and guidelines is that they're there to be challenged, and we need to challenge. But I'm sorry, I can't support 2A, but I would support 2B, and I would support recommendation 3 if there was a consideration to actually introduce a rural ward.
Thank you. Is any further? Thank you, Councillor Wang.
Thank you, Madam Chair, and through you. This has definitely been a really, really tough decision, just like the introduction of Māori wards. And having heard the very passionate speech from Mr. Biasinitule and Te Tatu o Te Arawa, you can definitely feel the emotion and the pain, I guess, through the historical wrongdoings. But from my point of view, when we first entered this whole discussion on representation and what does it actually mean for all of us, and after the submission hearings for the rep review, the conversation went from wards, which Māori wards are now guaranteed, to the number of votes each person has in our district. And the 334 option was brought up. It was brought up as an by actually quite a few members for us to consider, which would achieve parity. But the current option, the current motion 2A, with only one Māori ward, one general ward, and 8 at-large seats, and with both the community boards retained. And I acknowledge, yes, that does achieve parity, but hearing from members of our community, Te Tātou, it just does not reflect, I think, who they are and who we are. It diminishes their their representation to only one guaranteed seat when they were in fact asking for 3. And I'm really happy to support 3 and 4. I definitely think that that is the way that we need to go for greater parity. But currently, option 2B
which would guarantee two seats in the Māori ward, with the 4 seats in the general and the 4 at large, is much more palatable for me, and also makes me feel a bit more confident that we can actually have more diversity and voices at the table to discuss the really tough issues that we will be facing in our community and our district going on towards the future. Division is not what we need right now. We need unity. We need to be working together. And I will be supporting 2B. I won't be supporting 2A, unfortunately, today. Thank you.
Thank you. Okay, Councillor Kaifong.
Thank you, Madam Chair. Well, I came here today and I hadn't really made up my mind because I really wanted to hear what the debate was, because we really haven't had the opportunity amongst ourselves to actually discuss the new proposal that's on the table. We had a pretty robust discussion, I think, in terms of the original submission that was on the table, and we did hear from submitters and had the opportunity to read their submissions. And I think if we go back to where this journey started, which was about the introduction of Māori wards, and that was pretty much an overwhelming decision that yes, we should have Māori wards. And then it came down to this debate and discussion around yes, we'll have a Māori ward, but how many Māori councillors will we have sitting in those seats? And we've got into this, what I call a debate around, is it votes or is it seats? And yes, I know that the option 2A is around giving everyone the same number of votes. But if we go back to that original submission process, and the very earliest, simplest model, as Councillor McPherson refers to it, as 7-3, that was going to give Māori 3 seats. And we've now reduced that to 2 in the submission that we took out to the public, and we are now, with 2A, reducing that back to 1. We also haven't really taken into account the opportunity for how we could introduce a rural ward, and there were some quite strong submissions on that basis. So if I was to look at what I suppose they're not poor options, but I think we're forced into making a decision around poor options because of the way in which the law says we must make this decision. So I think that it's disappointing in terms of that process, that we can't do what we want without having to go through these convoluted steps to try and achieve a result. So for me, I would have to support 2B, because I think that that's closest to where we were with the original submissions. It honours our partnership with Te Tatu Aotearoa in terms of the engagement that they did. I take into account what Kihi had said around the reciprocity, and I think that what has come out through some of the submissions is the equity restoration was around seats at the table. We want our voices to be heard. We want to be guaranteed those seats, and it wasn't about that we needed the votes to be there. We just wanted to be there and have the certainty that we would. So I would be in support of 2B. I'm supportive of 3 and 4. Thanks.
Thank you, Councillor Kaifong. Thank you. I'm going to make a few comments at this stage. Oh, sorry, I'm going to make put my comments out there. I think it's quite unbelievable that we're 20 years out from the 200-year anniversary of the signing of the Treaty of Waitangi, and here we are all around the country benevolently saying we're going to allow 1 or 2 seats at the council table. It's unbelievable. It's unbelievable. And it's very unfortunate. It does actually say something about New Zealand, about our country. and what we've had in the past that has passed as leadership. But all this discussion that we're having right now, this time last year, it wasn't even on our table. We didn't even know that we were going to be doing this. I mean, 6 years ago, in the last representational review, it wasn't even on the table then, but it is now. And we are trying to fit ourselves in to the Electoral Act, and those on the Maori roll, they didn't know, and they didn't know that that's going to be determined, how the number of votes that they would get in the local authority elections. They didn't realise that. And Councillor Yates, you are quite right. Yes, it is about some seats here around the council table, but it is definitely about the people, about Māori on the Māori roll, having an opportunity to maximise their vote. And that has not been talked about here this morning. So we've got to understand that there's the real potential there for Māori who are on the Māori roll to not be able to have the number of votes that they would be like to have. And so that is already out there in our community, and they don't want to see that. I don't like the word trade-off, and I heard that used this morning because it's unpalatable to me. But at this point in time, what we have up there is something that I can live with, and I'm talking about 2A. It's something that I can live with at this point in time, knowing that there is an option under 3, and before the election next year, for some change to take place. And that's why I will be voting for 2A and supporting also 3 and 4 as well. I feel there is. I think this is a biggie, and I don't want it I would like to think that Te Tātou o Te Arawa, that it will not harm our relationship with them. They've put their views, and of course they put a submission in on that as well. But irrespective of that, I respect the views that we talked about, and with passion this morning. I think that has to be said. But at this point in time, I think, as Lachlan said, this is the second best option we've got that's been put forward at this point in time. So, look, I do speak in favour, and I'd like councillors who indicated that they would be speaking against it to clearly understand that Māori on the Māori roll should not have their votes in any way diminished by not having the numbers as everybody else would have. So, is there any further discussion? Are you worshipped? Would you like to? Thank you.
Right of reply, and I think it's been a healthy debate, but I feel very, very strongly that those that are saying they prefer option 2, being good on you for speaking out, because we're all trying to find the numbers and we're trying to do the numbers. It isn't about the numbers. It's about the fairness of how we vote, and that is only 2A with 3 and 4 attached. And Mrs. Trump is trying to bring in the rural ward. You know, that's right, you're a rural board member, and that's absolutely right. But I feel that's another consideration about it within a local bill. You are so right, Councillor Rokawa Tate. It feels to me like a diminished option and a diminished model. But it's tokenism too, to say that 2's good enough. 2's not good enough. What we heard was they wanted 3. Well, we can't have 3. And I believe that this is an iterative process. We should be proud, Rotorua, of the fact that we can have this open debate here today, and we can, and we are, and we will move with haste. And it looks like it's going to be a close vote, but you are shaping the future of our place by your vote today. And in my view, and my whole life has been a battle about Māori having an equal vote to others at the table, and 2B doesn't give that. So I put my life on the line as Minister of Conservation for co-governance on the Waikato River iwi entity. I put my life on the line for co-governance of Te Rotorua Lakes strategy. I believe in co-governance, and I feel very strongly about it. I remember my husband sitting there with Te Arawa Partnership when I shut him up as the chair and said, "You've had your time." What we believed in and fought for was equity for Maori, and only 2A gives that option today.
Thank you, councillors, committee members, for the discussion and your frankness and the full and frank discussions that we've had this morning. This is a biggie, and I'm sure it will be well reported, but however, and you will vote according to how you feel after listening to the discussions and your own feelings and your own research and the opinions that you hold. So excuse me, we did have a mover and a seconder, that's right. So I will put the motion, I have to read it, otherwise I won't be able to see it. Excuse me. Fine, thank you. So 2A, that the committee, after considering the submissions and requirements of the Local Electoral Act, recommends to Council to adopt a final representation model that consists of one mayor elected at large, one Maori ward with 1 seat, one general ward with 1 seat, 8 at-large seats, a Rotorua Lakes Community Board, a Rural Community Board. 3, that the committee notes that despite the 2 recommended options, a different model consisting of 3 Maori ward seats, 3 general ward seats and 4 at-large seats is the preferred model for representing the best needs of Rotorua in accordance with the principles of the Local Government Act and the Treaty of Waitangi, but that this model is not enabled under the current legislation. 4, that the committee recommends to Council that it instruct the Chief Executive to pursue the necessary statutory reforms or other means by which the preferred model can be adopted by Council at the earliest possible time, including, if possible, prior to the 2022 election. That motion has been moved and seconded. It's been moved by Her Worship the Mayor and seconded by Mr Thomas. I am going to put that motion now. All those in favour, would you please raise your right hand? Thank you. All those against, please raise your right hand. Six votes against. Chair's casting. So it's the chair's cast. Is it 6?
No. Yeah.
6, isn't it? Yes. 6 against. 4. 6 against and 6 for. Requires a casting vote, and I cast my vote for 2A. And for the motion that was for the motion that was moved and seconded, and I cast my casting vote accordingly. Thank you, councillors. I have, excuse me. Thank you. So I don't need a motion. No, confidential. So thank you very much, councillors. I will. Our meeting is concluded today, and thank you so much for your time. Thank you.